Hello, viewers. I read to you today an autobiography of Mr. B.V. Acharya, Senior Advocate, Karnataka High Court. The book is titled All from Memory, an Autobiography. The book, in hardbound, has been brought out by Law and Justice Publishing Company. I congratulate Mr. Sanjeev Arora of the Law and Justice for this very important and attractive, useful publication. The second edition has come in the year 2025. It's hardbound. The book is of 302 pages plus over 2 dozen pictures, and it is priced as rupees 995. Mr. B.V. Acharya is a senior advocate of Karnataka High Court, and this book is very interesting, and this would be useful to all connected with the legal profession. I start by reading from page 1. I was born in a poor family in Belpu village of Udupi Taluk, and the family avocation was cooking. My paternal grandfather, late Gopala Acharya, who was popularly known as Gopana Acharya, was a cook by profession who offered his services as cook at small social religious functions where the gathering was about 30 to 60 people. He was getting a remuneration of rupees 1 per day for his service as a cook. He was a pious and noble person, and he never got angry with anyone, even in the family. He had no enemies. He lived a full life and died at the age of 86 years, having suffered an injury to his leg due to diabetes, which was discovered later. The income he derived from agricultural lands was negligible. He was a kind-hearted person who never offended anyone, even under grave provocation. I was a small boy, aged 6 to 7 years, when he died. Turning to page 2, my father was married to my mother, Srimati Ratna Amma, from the same village. Marriage at a young age was a practice at the time. In fact, at the time of marriage, my mother was only 11 years and my father 16 years. My father was married even when he was a student. I am the eldest child to my parents, and my mother was just 16 years old when I was born. I moved then to page 23. As a student in the college, I was proposing to do my BT, Bachelor of Training after BA, and become a teacher. It is Shri K. Viswanatha Rao who totally opposed the said idea and encouraged me in good measure to become a lawyer. It is he who had very confidently told me that without doubt I would become a very successful lawyer and I should only think of doing law after my graduation. I next moved to page 29. On the very first day of my apprenticeship, 6th July 1956, I accompanied my senior to the court of the district magistrate with a criminal appeal. In Madras Presidency then, there were courts of second-class magistrates with limited powers, and the appeal against conviction lay before the district magistrate. In the case on hand, the appellant, a bus owner, had been convicted on a charge that the bus had taken a diversion and thus deviated from route permitted by the license and was therefore sentenced to pay a fine of rupees 5. After considerable arguments, the judge wanted to peruse the license, and then it was discovered that the bus in question was a relief bus and its license did not specify any route, hence the appeal succeeded. Next, page 32. When two eminent advocates appear on either side and argue the case expressing exact opposite viewpoints with relevant authorities on the subject, the listener acquires knowledge on the subject by merely listening to them. The continuous watching of performance of eminent advocates automatically teaches you several ways in which the defense can demolish the evidence tendered by the prosecution. By practicing in the trial court, one becomes very familiar with the procedural matters. Mere reading will not be a substitute for actual experience in the manner of procedure. Page 35. Shri B. Gangadhar Das was always immaculately dressed. He was fair and had a good personality, though he was bald. He had sense of humor and he did not hesitate to have it at his own cost. 2. Once when a client showed him a draft partnership deed for scrutiny, after going through the same, he remarked, "This deed is as bald as my head." Thereafter, he suggested insertion of several clauses in the deed to make it a perfect one. He told his juniors, "When you accept a brief, you must get either cash or credit." His point was that for the work done, you must either get money or you must win a case and thus earn credit. Moving to page 60. Even before I assumed office as chairman of the State Bar Council in 1979, the Bar Council of India had tentatively decided to establish the National Law School at Bangalore. Sri Ram Jethmalani, Ranjit Mohanty, V.R. Reddy, N. Rangaraj, G.K. Acharya, and Professor N.R. Madhav Menon are some of the leading personalities who played important role in deciding about the location at Bangalore. The decision was taken in view of the promise made by the government of Karnataka to provide sufficient vacant land for the purpose and also contribute a sum of rupees 50 lakh towards construction of building. Though the required land was granted, it is in this land at Nagar Bhavi that the present beautiful complex of National Law School of India University has come up. There was no written commitment regarding contribution of rupees 50 lakhs. Next, page 84. That evening, there was a get-together party where I met Sri N. Santosh Hegde, who had earlier served as Advocate General of the state and who had just then been appointed as Additional Solicitor General of India. Sri Hegde told me that his appointment as Advocate General was delayed by several days even after a decision was taken. As the clearance from His Excellency the Governor was delayed, Sri Hegde told me that it will take another 1 or 2 weeks before notification to be issued and I have to wait till then to assume charge. However, to my surprise, the next evening the Law Secretary, Sri N.D.V. Bhatt, informed me over telephone that the notification has not only been issued, but the same has been published in the special Gazette. Later, I learned that Sri Veerappa Moily, who had gone to Raj Bhavan to attend a dinner the previous night, had obtained the concurrence of the governor for my appointment, and that is how the notification was issued very next day. In the evening, the electronic media telecast the news about my appointment, and I went to Krishna, residential office of the Chief Minister, and for the first time I called on the Chief Minister, Sri Virendra Patil, whom I had never met before. I thanked him for the appointment. Next, page 158. This is chapter 25, case against Selvi Jayalalitha, Chief Minister of Tamil Nadu. In my career, the most sensational case which has received wide publicity in the country and abroad, in which I have appeared as a special public prosecutor, SPP, is the case in which Selvi J. Jayalalitha had and 3 others are the accused. The special CC number 208-2004 on the file of the Special Judge, Bangalore. The circumstances leading to the commencement of the case and its subsequent transfer to the Special Court in Bangalore by the order of the Honorable Supreme Court are as follows. Selvi J. Jayalalitha was the Chief Minister of Tamil Nadu between 1991-96. In 1996, after she demitted office as Chief Minister Tamil Nadu, Police Directorate of Vigilance Anti-Corruption, for short DVAC, filed 2 charge sheets, one in June 1997 and other in March 2001. In the first case, the charge was that A1, Selvi J. Jayalalitha, amassed wealth in India disproportionate to her known sources of income to the extent of rupees 66 crores and thus committed offence punishable under section 13(1)(e), read with section 13(2) of the Prevention of Corruption Act. It is the prosecution case that the other 3 accused in the case have either abetted the commission of the offence or have been party to criminal conspiracy. The case is generally referred to as wealth case. The second charge sheet was against 2 accused. Accused 1 is Selvi J. Jayalalitha and accused 2 is Sri Dinakaran. In this case also the charge is similar to one in the first case, but disproportionate asset was acquired in London. It is claimed that two valuable hotel properties, valued at about pound sterling 81 lakhs 54,956, were purchased by accused number 2 in the name of companies floated by him, and that the consideration amount was ill-gotten wealth of accused number 1. This case is known as London Hotel Case. Moving to page 201 to 3. Judgment, a brief analysis and effect. The case of Selvi Jayalalitha is indeed a pioneer and a landmark case dealing with corruption in high places in our public life. The accused Selvi Jayalalitha was a very popular and powerful mass leader in Tamil Nadu and wielded a lot of influence and sway over the masses who were even prepared to sacrifice their lives for her. She also had the reputation of being a capable administrator and a consummate politician. The other three accused were no less powerful, influential, or resourceful. They were educated, clever, and worldly wise. All of them had the best of advice and assistance: legal, commercial, financial, accounting, banking. They combined their vast knowledge and experience with expert advice and almost successfully camouflaged their activities, such as forming companies, firms, opening bank accounts, to ostensibly show their illegal acquisition as lawful. They indulged in various devices in their attempt to circumvent the law and to not fall in its clutches. They indulged in amassing wealth by dubious means. They devised ways and means to see that their offenses do not come to light. All these attempts of the accused were foiled by a thorough and penetrating probe by the investigating agency. As the trial, the accused took up all defenses that could possibly be taken, yet the prosecution could deftly pierce the corporate veil and lay bare the actual state of affairs. The Supreme Court was able to see through the game and put everything in the correct perspective. The court effectively demolished all their defenses, relying on clinching circumstantial evidence, and laid down legal principles which will serve as important guideposts and precedents for future cases. No stone was left unturned to delay and obstruct the prosecution. They even tried to dictate the course of the prosecution and had a prosecutor of their choice. Yet, in spite of all this, nemesis caught up with them, resulting in conviction and sentence. Only prior to the pronouncement of the final judgment by the Supreme Court, Jayalalitha's demise saved her from undergoing the rest of the sentence of imprisonment, having already spent some days in jail upon her conviction and sentence until she obtained bail as the state appeals against her abated. It's a pioneer case because it is for the first time that someone holding such a high position of power and authority as the Chief Minister of a state was found guilty of and convicted in a case under the Prevention of Corruption Act for possessing wealth disproportionate to the known sources of income. It is a landmark decision that has set a benchmark and heralded a change and set the course of law for future generations. The judgment has comprehensively dealt with the various nuances of the Prevention of Corruption Act. It has addressed different aspects, answered several questions of law in favor of the prosecution, and closed all escape routes of the corrupt accused. It has also laid down guidelines for the future. That is the importance of the judgment. Significantly, all the contentions of the prosecution were accepted and all the findings of the trial court were affirmed. The short concurring judgment of Justice Amitav Roy, couched in his own unique style, served as a much needed reminder to the public that their eternal vigilance and active participation alone can help eradication of corruption in public life and act as a preventive in future. The judgment should hopefully serve as a deterrent to all men in public life holding high position who may be tempted to indulge in corruption. The judgment appears to have seen as far as one may and plugged all the loopholes and bolted the doors for escape. But human ingenuity knows no limits. It is ultimately the eternal vigilance of the public at large, that citizenry, that would ensure probity in public life. To adopt the language of Derbyshire Chief Justice, NRC Polen versus Satya Gopal Majumdar, AIR 1943, Calcutta 594. Persons in public life are to be left to the contemplation and judgment of their fellow men. Such contemplation and judgment of fellow men should be vigilant and strong enough to drive the unworthy out and ensure that only worthy people occupy public life. This book will undoubtedly be useful and of interest to all connected with the law domain, public policy, and the civil administration, particularly those dealing with constitutional law, criminal law, Prevention of Corruption Act, and various other legislation. It would be a useful addition to their law library. Thank you.